Today's webinar is focused on conducting workplace investigations in the not-for-profit sector. We are going to look at the unique issues faced by employers in this sector. We're going to look at best practices when it comes to conducting investigations. We are then going to take a look at how to manage an external investigator to the extent that you need to bring in a third-party investigator, and how to manage the costs that are associated with that process. We'll then look at issues on the back end of the investigation after you have completed your work and you've prepared this report. Do you then need to publish that report to your stakeholders in order to preserve the reputation of the organization? So we'll look at issues around, potential reputational harm to the organization as balanced against the potential for reputational harm to the responding party. As always, we've reserved a lot of time at the back end of this presentation to answer your questions and to help you through any investigation challenges that you might be experiencing. My name is Dorian Persaud. I am the senior lawyer at Persaud Employment Law. We are a team of lawyers who are focused on and who specialize in conducting workplace investigations, and we help you to create healthy workplaces through investigations, training, and proactive advice. So when it comes to doing this work, we have to look at why do we even conduct investigations in the first place? So the starting point would be the legal framework, and we have an obligation under occupational health and safety legislation across this country that requires employers to provide a workplace that is free of violence and harassment. And so that would require us to then look into concerns of misconduct when they're brought to our attention or where we have reason to suspect inappropriate behavior. Even before the changes to the Occupational Health and Safety Act, though, there were decisions from the Canadian and provincial human rights tribunals that required employers to look into allegations of discrimination. So where an employee came forward and said, look, my human rights have been violated. I've been discriminated against on one of these prohibited grounds. Tribunals have said, you employer, you can't just dismiss these issues. You need to look into them and make sure that there hasn't been a violation of the code before you can then move past it. And there have been cases where employers have incurred liability and been fined because they basically failed to investigate a complaint of discrimination. So you're doing this work, in that legal framework, but you also have to keep in mind that this is also a reflection of the values of the organization, right? Many of you have a code of conduct or another policy document that says, here are the values that we want to live by. And when you conduct an investigation, you bring life to the policy. You actually demonstrate that these words and these policy statements, that we stand by them, that we believe them, and that we're prepared to enforce them, because this is the type of community that we want to foster. So conducting investigations, again, helps you to bring life to your policies and ultimately reinforces a positive culture and a healthy workplace. We're going to look at some best practices when it comes to conducting investigations. And it starts with the receiving and screening the complaint. So not every allegation gives rise to a formal investigation, right? You need to ask yourself a few key questions. And one of those questions would be, look, if these allegations are true, do they violate any of our workplace policies? And if the answer to that is no, then you may not need to go further, right? So there may be some troubling behavior there, and it may be still warrant someone looking into that behavior. But in terms of, does this trigger a formal process on the part of the employer? Again, if there is no potential violation of policy, then that would, in most cases, lead you to conclude that an investigation is not warranted. You also have to look at what is the potential for liability here. One of the first investigations I did in my career was a situation where a nonprofit the board of a nonprofit was presented with allegations from a number of their staff. They had 10 managers who came forward and said, we're being bullied by the executive director. If you, the board, don't do anything about this, we're going to walk off the job and we're all going to claim constructive dismissal. So as you can imagine, it was a very serious situation. We came in, conducted the investigation, advised the board, and were able to help them navigate that. But certainly where you have that scale of disruption and the potential for significant liability, that would militate in favor of a formal process. And then finally, is there a violation of any statutory obligations here? So, for example, the Human Rights Code, where the code is engaged, again, that might militate in favor of a formal investigation. When it comes to initiating the investigation, one of the pitfalls that we often see is employers who maybe receive a document in writing, maybe it's an email from the complainant, and they assume that written document, that email, that contains the whole story, that gives them everything they need to know, and they can then take that document and run off and conduct the investigation. And that's a mistake for a couple of reasons. First off, it's very rare that you would get all of the information that you need in that initial document. Certainly, there's a lot of details in there, and it's a good start, but it really just touches or highlights the concerns that the individual has. It's not until you meet with them that you're then able to fill in the gaps. So if someone's complaining and saying that they've been intimidated by their boss, and maybe hear some things that were said, well, you don't have, from reading that document, details such as, when these incidents may have occurred, what was the physical proximity of the parties. If the complainant is saying that certain things, threatening behavior, there was certain threatening behavior, whether it was words or actions on the part of the respondent, where were they standing? Were they kind of hovering over the complainant? Were they a number of feet away? What was actually said? How was it said? What's the proximity of the parties relative to each other? There's a lot of detail there that's very important in terms of you being able to investigate and determine whether or not there was inappropriate behavior here. So you want to make sure that you don't gloss over that and do meet with the complainant to get that information. The other aspect of it is meeting with the complainant has a cathartic effect for them, right? Like meeting with a complainant is the first opportunity that they have to be heard. They have, allegedly suffered with these incidents, usually over a significant period of time. They finally worked up the courage to come forward, and sitting down with an investigator, whether that's internal or external, is their first opportunity to be heard. So you don't want to miss that opportunity, because that's really key in terms of reassuring the individual that you take their complaint seriously and that you're doing something about it. And the final point I'll make on that, a meeting with the complainant, is simply that I've been involved in so many cases where the employer was taking the complaint seriously. They were investigating the issue, but no one had either met with the complainant or no one had followed up with the complainant to kind of say, look, here's what's going on. Here's an update on where things stand with our investigation. So the complainant was left thinking that nothing was being done. Meanwhile, a whole lot was being done. And the complainant, in frustration, or maybe they get bad legal advice, they rush off and they file a human rights complaint and or initiate some other legal process, when simple communication could have alleviated that. So communication is so key in these circumstances, and you want to start off on the right foot at the beginning of the investigation. Coming out of that meeting, you're going to prepare what's called the particulars of complaint. It's simply a list of the allegations the complainant has, and it gives you an opportunity to say to them, look, I listened to you. Here are the 10 things that you were complaining of. Can you just confirm that I have captured your story accurately? These are the things that we're going to then be investigating and raising with the responding party. And as the last point on this slide is, that sets your mandate, right? Like, these particulars are your mandate. Another mistake that we often see made is an investigator will run off. They'll have their mandate, but they stray from that because there's interesting allegations that come up when they start asking questions, and they maybe become aware of an affair in the workplace, or someone who is claiming overtime hours that they didn't work. There's a whole host of rabbit holes that you could explore, and having a clear sense of your mandate helps you to stay on track and be deliberate in terms of how you're approaching the investigation, and maybe parking some other issues that are interesting and may warrant investigation, but not by you, or maybe not by you at this time. So that's an important a pitfall that you want to avoid. So one of the things that I wanted to raise is, as you've met with the complainant and you have these list of allegations, one of the things that may come up is, the allegations may be serious. They're in some cases, there may be potential criminal liability here. What is your duty? What is your obligation to notify the police when it comes to the potential for criminal liability? And the short answer to that is that employers do not have a general obligation to bring these issues to the attention of the police. However, there are some exceptions to that. And so where you are dealing with a minor, the Child and Family Services Act would require that the employer bring issues to the attention of the police and other applicable authorities where a minor, again, a child under the age of 16 is 16 and under, the fear is that individual is at risk, has been harmed, or is at risk of harm, and therefore that protection is warranted, or alerting the necessary authorities is warranted. And similarly, we see that obligation for the elderly and protection for those in retirement homes and long-term care facilities. So under the Retirement Homes Act and the Long-Term Care Home Act, there's similar obligations where if an elderly person has been abused, or there's a belief that the individual has been mistreated, that information be brought to the relevant authorities, again, including the police, to be investigated. Another context here is regulated health professionals, right? And doctors and nurses and lawyers would have professional obligations when it comes to reporting misconduct against vulnerable individuals. So these are issues that certainly do come up from time to time, and it's something that you want to be aware of and be mindful when it comes to your obligations in that regard. One of the questions, one of the implications that come from this then is, if there is a parallel police investigation or a regulatory body that's then conducting an investigation, you potentially have these multiple investigations happening, right? In parallel, you've got your workplace investigation on the one hand, and then a criminal and or a regulatory proceeding happening as well. So in that circumstance, I often get asked the question, Dorian, do we even need to go ahead with our own internal investigation? Like, the police aren't the police just going to take care of this? And the answer to that is no, because you have to understand that the police are looking at this through a very different lens than you, the employer. So the police are looking at this through the criminal law lens. And, is there enough evidence here for them to be able to convict this individual, or for a prosecutor to convict this individual beyond a reasonable doubt? And that's what they're looking for in terms of collecting their evidence and putting their case together, and ultimately having a prosecutor recommend whether or not to move ahead with charges and a prosecution. From the employer perspective, you're looking at this on a lower standard of proof. So you're not looking at it as beyond a reasonable doubt. You're looking at this, the standard is on a balance of probabilities. So is it more likely than not that these things happened? If you want to put a numerical value on it, you're looking at 50% plus one. Is it more likely than not that when you weigh the evidence, it's a little bit more likely that these things happened as opposed to not? And so that's the basis on which you're then moving forward, and your obligation is to move forward in an efficient and expedient way, because the obligation is to preserve and maintain a workplace that's free of violence and harassment. So you still have an obligation to pursue your own investigation, even though there may be other proceedings that are underway. Another related point here is whether or not the responding party is going to participate in the investigation. To the extent that there are criminal charges that are pending, the responding party may look at the internal investigation and think, well, if I say something to the investigator, that information could be used against me in the criminal proceedings. So that information may be obtained by the police and then used as evidence in the criminal trial. So depending on how quickly things move and how quickly the internal investigation moves relative to the criminal investigation, there may be some questions there for the responding party. At the end of the day, that's more of a strategic decision that the respondent and their lawyer are making. From the employer's perspective, certainly the respondent, up until a decision has been made, is still an employee of the organization, and there's still a duty for that individual to cooperate with the internal investigation that you are conducting. So you can make best efforts to try and move ahead on those grounds, but I kind of flag that as a potential issue where you find yourself in this type of a situation of having parallel proceedings on the go. And this brings us to the issue of when to use an external versus an internal investigator. And one of the points that you want to consider is who's involved in these allegations. Are these allegations that are against a senior person in the organization? And if that's the case, then you want to ask yourself, can we truly investigate and conduct a rigorous investigation internally? To what extent can the HR manager really sit down with a member of the board of directors or with the executive director of an organization and hold that individual to account? So where you've got a senior member who is alleged to have engaged in problematic behavior, that might be a situation that weighs in favor of having an external party involved. Another consideration would be the potential for legal proceedings. We talked about the investigation I had where you had 10 managers who were going to walk off the job and claim constructive dismissal. So certainly, if you face the prospect of a significant civil claim or a human rights claim, that may warrant and that might lean things in favor of having an external investigator, just because you want to be neutral in terms of how you're approaching this work. You want to make sure that it's done in a way that's going to stand up to scrutiny in court, at arbitration, or at a tribunal. And having an external involved may be beneficial then to the corporation in that instance. And then the final point on this is you want to make sure that you're doing this work obviously free from bias, but also free from the appearance of bias, right? We have a lot of examples in case law where employees see that an investigation was done, but they also see that the person who did the investigation has worked for decades with one of the parties involved in the investigation, whether that's the respondent or the complainant. And at the end of the day, even if you do a good job, the question remains, did both parties get a fair shake in that investigation? So you want to make sure that when you undertake this job, that you're obviously doing it with integrity, but you want to make sure that it's free of bias and free from even the appearance of bias. Otherwise, it calls into question the whole process. And an answer to that question, again, will help you decide whether or not to go internal or external with the investigation. And related to that is the issue of cost, right? Cost is the big issue when you're bringing in an external investigator. And one of the ways that you can manage cost is by looking at the things that are driving the cost and seeing to what extent you can cap those expenses. So the main drivers of cost when it comes to an investigation is the interview stage and the length of time it takes to get through the interviews, and then report writing and the amount of time that it takes to prepare a comprehensive investigation report. So when it comes to the interviews, one thing that you can do is maybe work with the parties to put a cap on the limit for those interviews, and have the parties agree that, look, you've got 2 hours to tell your story to the investigator, and you try to do your best to tell your story within that time. And if there's a union involved, the union is going to have a say in this as well, as far as procedural fairness. But that putting a time limit on interviews is one way to place a reasonable constraint and be able to manage your costs in a predictable way. Another issue is the conduct of the interviews and whether or not those are done in person or via video conference. I would say since the pandemic, there was that transition from in-person to video conference interviews, and that's become the norm these days. So that saves a lot of time and alleviates the travel expense of having to travel to a location and rent a room and conduct the interview in person. So that's another way that you can save costs, again, where it makes sense to conduct the interview virtually. And then another thing that you want to do is, if you're working with an experienced investigator, they should be able to provide you with a quote for the investigation. They should be able to lay out for you what the scope of the investigation is, and here's the price for that service. And that quote should be reflected then in your retainer agreement with that individual. And certainly once that's in the agreement, the parties can make changes to it. So for example, where the mandate is expanded, or there has been some development that might warrant the investigator to meet with more witnesses, whatever the case might be, the parties can certainly, the investigator can bring that back to the employer and discuss that and make those changes and reset the expectations in terms of cost. But it's helpful at the outset, again, to have that budget to work with, so that there isn't sticker shock at the end of the investigation. The next slides that we're going to cover just deal with best practices around collecting evidence. And we talked about how these meetings are being done virtually. So you want to make sure that in that context that folks really understand and respect confidentiality. We have been involved in situations, I can think of examples with investigations I've done for various school boards, where the individual believed that they could record the investigation interview. Some folks even have a belief that they can live stream an investigation interview. So many of you who are working in a corporate context, this might be news to you, but certainly, when you cast a wide net and when you look at the certain groups that might be involved in an investigation, and especially, again, a school board setting with parents and third-party advocates and others, there are they don't necessarily adhere to the norms or understand what the norms are when it comes to these processes. So certainly you don't want to take anything for granted and make any assumptions. You want to make sure that everyone's aware of the obligation to maintain confidentiality, and you want to make sure that you're aware of who's in the room, and make sure you're aware that, or make the other side aware that they're not to be making a recording of the event. You yourself will want to be making a recording, excuse me. You will want to be making a recording of the event, though, when it comes to the questions that you ask and the answers that are given. Again, because many of these interviews are being conducted via video conference, it's very easy to hit the record button and transcribe the interview. And that way you've got an accurate record of what what was said, the questions and the answers that were given during the interview. In some cases, you may also be typing your questions and answers as those are being given. And I know some organizations where they have the luxury of being able to send two individuals to conduct an interview, one to ask the questions and one to be a note taker. So in whatever your reality looks like, the point is that you record the interview and that you, at the end of it, prepare a transcript that you get the witness to sign off on. I've seen cases where a client will conduct the investigation, make findings, you prepare a report, and then you have one of the witnesses putting up their hand, usually after you've made a finding against them, and the respondent will say, well, I never said that. And to avoid that happening to you, or one way to put limits on that is to tie them down, is to say, well, here's the transcript, we presented it to you, you signed off on it, or at a minimum, you didn't get back to us with any changes. And so this is an accurate reflection of what we discussed. There's some trust that you can have in that document at the end of the day. A lot of your cases are going to come down to credibility. And the reality is that you don't often have witnesses for every event. And in these situations that come across your desk, and certainly the ones that come across my desk, these are the difficult cases, and you have to find a way to put the pieces together and figure out who's telling you the truth. And I can tell you from experience that you can't just look at how confidently people speak and whether or not they look you in the eye and whether or not they have an even voice and just judging them based on their body language. People will look at you and smile and speak confidently and lie to you. And you have to find a way to get to the truth of the matter. And there's one case that we did where it was a he said, she said situation. The complainant was female. She complained that her boss had propositioned her when, as she turned down his overtures, he started taking away hours from her. And so she suffered financially because of that. When I interviewed him, he said he was confused by the complaint. He had no idea where this was coming from. She was just another worker that appeared on his schedule. He scheduled all his workers in the same way. And there was a downshift in business that would explain the reason why she was deprived of her shifts. When I asked about how well he knew her, indicated that he hardly spoke to her. When I interviewed her, she was able to tell me intimate details about his life. She knew about his relationship with his wife, about the difficulties that they were having. She knew where he lived and when he moved there and how much he paid for his home. She had all of these, very intimate details that are not public about this man's life. And when I had a follow-up interview with him, he couldn't explain how she knew all of these things, again, because his initial position with me was he hardly spoke with her. She was just another worker. So we were able to then make a credibility assessment in favor of the complainant and make our findings from there. But that's not easy to do, right? I've been litigating cases for almost 20 years. It becomes second nature in terms of knowing what to ask and being able to pick up on certain nuances and follow an instinct and put the pieces together and make a credibility assessment that's going to stand up to scrutiny. But so really being good at this comes down to experience, and we are putting together a course specifically on how to make sound credibility assessments. So if that's something that's of interest to you, please do let us know, and we'll make sure that you get advance notice of that course when it's released in the weeks ahead. The final thing that you're going to do is to make a finding. And in many cases, there's the temptation to say, well, so-and-so said this, the other person said that. I don't really know how to call this, and so I can't make a finding on I've got contradictory evidence. I can't make a finding here. That's not good enough. You have to make a finding on each allegation. Either it happened or it didn't, again, on a balance of probabilities. So you don't have to prove this beyond a reasonable doubt. And the reality is that you may get it wrong sometimes, but we're not here to be held up to a standard of perfection. You are doing the best that you can, and you are working within a framework and being diligent about going about this work and following a process. And at the end of the day, making a judgment call after weighing the evidence that you've collected. One of the questions we often get asked on the back end of an investigation is, Dorian, do I have to give a copy of the investigation report to the parties? And the answer to that is no. The parties are only entitled to the conclusions of the report. So you would typically give them here are the allegations that were made. Here are the conclusions to each of those allegations. And there might be an overall conclusion that says, after considering all of these behaviors, there is or is not a pattern of behavior here that would constitute harassment. So in some cases, you may provide more. You might provide an executive summary of the report. In some cases, you may hand over the entire report. Again, it's very contextual, but for the most part, at the end of an investigation, the parties are only entitled to the conclusions and not the full report. Finally, once you have the report prepared, one of the issues that sometimes comes up is, should we release this to stakeholders? Do we make this report public? And this issue of publishing the report and in order to protect the reputation of the employer, I find this easier to understand, in the context of theological schools or a religious organization. You might have a senior person who's accused of sexual misconduct, and you've got a student body or others in the community who are really concerned about what happened. And the conclusions of the investigation and what happens afterwards in terms of how the organization responds to that misconduct, that is extremely important to the stakeholders and to the members of that community. The future success of that organization or that school or that ministry depends on the organization getting it right. So in those circumstances, you could see they have to weigh, look, what is the potential for damage to the reputation of the respondent and us facing a claim of defamation, and you weigh that against what's the harm to the organization if we don't release this, and if we keep this under wraps. Does that lead to suspicion and mistrust, and what damage does that do to our ongoing operations? So in that context, you do see in very limited cases investigation reports being made public. Obviously, you want to make sure that you've weighed the proper considerations, and you want to make sure that from a substantive point of view, that the conclusions that you've made in that report, that they are grounded in evidence, and that you have some confidence that those findings are going to stand up to scrutiny. So you see this with the case currently with Hockey Canada and the 2018 World Juniors, where that report was made public. Again, for those reasons where you have multiple stakeholders, it's a very public case. There's government funding that is at stake, and the organization weighed all of those factors in terms of then making a decision to release the report, so others know that this is being dealt with or was dealt with in a robust and in a transparent way. But again, these are very complicated decisions that you need to work through and to get good advice in order to determine what is the best path forward for you. So with that, we'd like to we have the final slide just summarizing the best practices that we laid out in terms of the investigation and what you need to do to at each step of the way, whether that's at screening the application, the complaint of misconduct, whether that's collecting the evidence and then preparing your report. We took you through the best practices at each of those stages, and then also provided you with tips on when to go with an external versus an internal investigator, how to manage costs with the external investigator, and again, the issues that might come up around notifying the police where there's the potential for criminal liability, and then determining how much of your findings to publish if there is that risk of reputational harm. So we trust that that information is helpful to you. Again, my apologies for the technical difficulties that we experienced today, but you will get a copy of these slides, and I'm happy now to open up the floor and answer any questions that you might have. So I'm just looking at the Q&A section here. And there's a question here. As the HR or in-house investigator, do you incur any liability for the wrong conclusion? That is a great question. And there are a number of cases out there that have confirmed that the employer is not liable for getting it wrong. You, again, you have that statutory obligation to conduct the investigation. You take that step to preserve a healthy workplace, one that's free from violence and harassment. And the reality is that you may get it wrong. So the fact that you get it wrong doesn't result in liability for you. And again, and especially where you've done the work, even if it crosses the line from not just getting it wrong, but you may be negligent. There isn't a claim against the employer for conducting a negligent investigation. There is, however, if you bring in a third party and that individual is negligent in their work, certainly there's liability that individual would attract, and the complainant who was affected by the negligent job that was done can certainly bring an action against the investigator. But if, again, as an employer, in-house, conducting an in-house and internal investigation, there aren't any claims that, or there isn't any potential for liability there for, as I said, for doing an honest job and just getting it wrong. Another question is whether or not there's any legal requirement related to turning in an investigation report or making a finding. Again, when it comes to these, what I understand the question to be is if there's overlapping events, you may have an internal investigation and a criminal investigation. Is there a legal requirement that you hand that over to the police? And maybe Mark, who asked this question, could correct me if I'm wrong in that, in my understanding of the question. But when it comes to turning over the investigation report to police, there's a formal process that the police can initiate to get access to that report. But certainly, there's no obligation on the part of the company to hand over its work product to the police. At the end of the day, they're doing their own investigation. They're responsible for that. But it's not unusual. We've certainly, in our experience, been approached by various police services and asked to see the results of our credibility assessment, maybe because that would be helpful to the detective or inspector, whoever is conducting the work on behalf of the police service. So it does happen from time to time, but certainly there's no formal, statutory obligation to hand over the investigation work product to the police service. Another example that's come up is whether or not there's a duty to investigate a situation where a warehouse manager is staring aggressively at another employee. Is that something that triggers an investigation? And that's a good question, right? You often get a range of complaints. And when you get these lower level complaints, and so for the example here that Lene's raised, that in and of itself, a single incident of staring at someone in an aggressive way, that doesn't meet the definition of harassment. In most cases, in most legislation, harassment is defined as a pattern of conduct. And so you're looking at repeated behavior that's known or ought to be known to be unwelcomed. And so certainly if you've got someone who is constantly acting in an intimidating way, that would meet the definition, of harassment. But one allegation of staring is not going to do it. Now, what do you do as the HR professional? Do you dismiss it, given that it doesn't on its face violate the policy, or do you look into it in an informal way? And I would say that you want to just speak to the individual involved. You can have a word with the manager to just find out what happened on the day in question, and just let them know that that they need to act in a professional way. Even if you're upset and even if you're exasperated with an individual, you still need to be professional. So that doesn't mean you have to be perfect and you're not allowed to show any emotion, but certainly you want to keep those emotions in check and make sure that you communicate your displeasure or whatever it is to the other employee in a respectful way. So that's the obligation, right? Is just to treat other people with dignity and with respect. And certainly you have to be mature enough to communicate bad information and negative information in a respectful way. So that's really the word that you want to have with the warehouse worker in this situation, is just letting them know, here's what the complaint was, no violation of policy, but what's actually going on here. Can you conduct yourself in a way that's not going to attract a complaint here? We have a question here from Dominic. How do you ensure that any personal biases or assumptions don't influence the outcome of your investigation? At the beginning of every investigation, one of the things that you want to do is really go through that process of checking your bias, and we have to keep in mind here too that includes unconscious bias. So all of us are biased. All of us grew up and have certain experiences that shaped us. We learned from those around us, both the good examples and the bad, and we take all of these experiences with us. And it's a very difficult thing to do, to sit down and have to check and realize, identify, right, that unconscious bias, and then be conscious of it, and understand to what extent that might be affecting the way that you're doing the investigation. So once you go through that process of accepting that you do have these biases, and you then are monitoring that through the investigation, and asking yourself honestly if you believe that you can honestly approach this work, or if you could put those feelings aside, and maybe it's feelings of mistrust, or maybe it's something again that the way that you were raised. A really benign example of this would be you're investigating someone who is habitually late and doesn't keep commitments at work, and they're being performance managed, and you're being brought in as an HR person to help look into this and help with the performance management maybe, and you yourself were brought up to always be punctual and always be on time and be respectful of other people's time, and that was just there was a high value placed on that with you. So if you grow up with that, and that's the way that you conduct yourself, and you're then going through this process with this individual who is on the other end of the spectrum from where you are, and you're having to kind of come to grips with the reason for this behavior and whatnot, that's a situation where you just have to recognize that bias that you have. You're not going to have the kind of respect for someone who disrespects time, and because that's not the way that you were raised. That doesn't mean then that you can't continue with the process or that you need to excuse yourself from the process, but it's just something that you need to be mindful of. Obviously, there's more serious situations where you recognize the bias that may then impede your ability to be neutral and approach it in that dispassionate way, and where you do need to step away from it. But yeah, that's an excellent question, Dominic, about the process you then have to go through and constantly evaluate as you're going through the investigation to really know if this is something that you need to step away from. Another question that came forward is, are there any specific differences between Canada and the US and the materials that we presented? And so the answer to that substantially would be no, that there are the same obligations in the US to provide a workplace that's free of violence and harassment. And certainly there's that obligation to investigate allegations of misconduct. And again, depending on your state, there's going to be different obligations when it comes to that positive obligation, right, to report misconduct to the police. We talked about generally that not being an obligation, except in circumstances where you are dealing with a minor, under the age of 16 years of age or younger, or you're dealing with the elderly. So there may be other exceptions, again, depending on the state in which you work. But that's still good guidance for the most part in terms of identifying this issue. But the steps that we took you through in terms of conducting the investigation and the considerations at each stage, and making a credibility assessment and what is required to be provided to the parties, certainly there's consistency there between the material that we presented and what you would experience in your state. Another question that we have is it enough that an investigation was conducted internally, but no discipline was necessary, especially since the parties apologized and resolved it? So that's a great question. What is the appropriate response at the back end, on the back end of the investigation? In the situation that Manav just described, it sounds like it was lower level misconduct. The parties were able to acknowledge their role in that and were able to speak with each other and resolve it and move on. There's other cases where, say, for example, you are dealing with a sexual assault in the workplace, and even if in that circumstance the complainant and the victim says, you know what, I can have a facilitated discussion and move on from that. That's a situation where you as an organization, you really have to take a hard look at whether or not that's in the best, even if the parties are okay with it, if that's in the best interest of the organization. What message does that send to other employees who aren't really familiar with the nuances of the personal relationship and how they were able to make amends? What others see is that there was a serious sexual assault, that this was investigated by the employer, and this person is still working here. And so did the employer condone this behavior, right? Like, it's really hard to come back from certain types of misconduct. And that would be one where, likely you're going to have to, you should, part ways. Otherwise, there may not be legal liability because the parties have made up and they're fine to continue on, but you are still doing harm to others in the workplace who you may be affected by it. And you could see, again, an erosion in the culture, an erosion in the trust, and maybe an exodus of talent, right? Because people are just shocked that, this perpetrator is allowed to continue in his role, presumably without consequence. Okay, we have a question here when it comes to resources that Melissa's asking whether or not she can bring in, because the HR department is small, can she bring in a manager to help with an investigation if necessary? And you want to, and certainly you can bring in someone else to another manager to assist with an investigation. You want to make sure that that manager obviously is not involved in the factual framework at all, that they're not a potential witness in the investigation. You also, we talked about the issue of bias or perception of bias. You want to make sure that they're not on friendly terms with any of the parties involved. And just to expand on that, it's not necessarily that you're friends with the individual involved, but sometimes just two people having worked in an organization for a very long time together. Again, they don't golf on the weekends, they don't socialize outside of work, but just the fact that they've got this long-standing working relationship, that might be enough to tip the scales in terms of them treating one party with a little bit differently or more favorably than another party. So again, those are just the considerations. You want to, whoever you bring in, make sure that they're neutral, make sure there isn't any issues that are going to create bias or a perception of bias. And to the extent that you've got another resource there, the fact that they don't work in HR shouldn't tie your hands in terms of using them, as long as they understand their obligations regarding confidentiality, especially as it relates to the investigation. Another question that's come in is from Amanda. Can you share your thoughts on what's required to be shared to meet the OSHA expectation that this is the Ontario Health and Safety Act expectation that the worker who has experienced harassment may be informed of any corrective action that has been taken or that will be taken as a result of the investigation? So typically what you want to do is to let the worker know that you've investigated their complaint and you're committed to creating a safe environment. And at a high level, you might say that depending on the facts of the case, maybe the responding party, that there are steps being taken with the responding party to address the alleged misconduct, or if there's a finding of harassment and misconduct. There may be steps taken even outside of a finding. Maybe there was no finding of harassment, but it was problematic, and so you just let them know that steps are being taken with that individual. Here are the other steps that are being taken, maybe structurally to the workplace, in order to address the findings from the investigation. Maybe there are improvements being made in the way that complaints are being handled, or the procedures, right, that are in place when it comes to dealing with the behavior in question. So there's a range of solutions and actions that an employer is going to take in response to the findings of an investigation. And certainly you can make the worker aware of some of those things specifically, but when it comes to the specific discipline, if there is discipline against another worker, that's going to that's confidential information, and that would not be shared with the worker. So it's not to say that you're not taking those steps. It's just that one worker is not entitled to know that you are suspending another worker for his or her alleged misconduct, right? So you're just balancing off those you're meeting that obligation, and by providing some high level information, while also balancing off and respecting the duty of confidentiality that you owe to the individual respondent. Okay, that has been a lively discussion. I know there are some questions that we weren't able to get to, but we'll make note of those questions. I see that there was a follow-up from Dominic here, or another question from Dominic that we weren't able to get to. But certainly we will, please, we will follow up with you individually and respond to your questions if we weren't able to do that during this live chat. I want to thank you all for your participation today. If there are topics that you want us to cover in the months ahead, please do let us know. We are happy to prepare and these materials. We know that you enjoy them, and we want to continue providing material that's going to be helpful to you in your practice. Happy to send you an invite as well if anyone wants to have a virtual coffee with me because they want to unpack a legal issue that they might be facing in their workplace. I'm happy to do that as well, and we'll send you a link where you can make those arrangements for us to connect. So thank you again for this time that you spent with me this afternoon. Appreciate your patience with the technical issues, and I do look forward to connecting with you next month when we look at sexual harassment investigations. We'll specifically unpack the situation with the Canada World Junior team and the unique considerations in the criminal law. We'll have a criminal law lawyer on the panel with us to help unpack those investigations through the employment law and the criminal law lens. Thank you very much, everyone, and wish you all the best.